Yes, Mr. Barnes.
My lords, my lady, thank you for the time over the luncheon adjournment. Just by way of some tidy up of matters from before, from this morning. Firstly, when I believe Mr. Nottage emailed the court with two judgments. One was X and Y, the other was NS and Croatia. I realised that in providing the first of those to my lady, we hadn't provided the second NS Croatia. So I hope that that's been handed up. The court should have that otherwise electronically, but there are other copies if required. And then over the luncheon adjournment, again, we have sought to provide, and I'm very grateful to those instructed on behalf of the children, who I think have managed to track down a copy of the Kafkas guidance that was somewhat eluding those assisting me, but their link to Kafkas Legal was somewhat more direct than ours.
And it was revised in 2015. It makes it even more difficult to find the revision.
Yes, so the court should have, and I apologise that we don't have hard copies for my lady. We can obviously provide them. Excellent. So we have provided, or I say we, I'm taking credit for Mr. Nottage, Practice Direction 12I, the original Kafkas Practice Note of 2005 and the amended version in 2015. So I think that's been a somewhat collective effort to try and supply the material that was the basis of my lady's inquiry. If I might take it in the order I'd addressed it, the NS and Croatia judgment, I just wanted to refer to it. It's raised within the X and Y decision, and that was the basis on which we had identified it. On page 27 of that authority, at paragraph 94, it was just to assist by drawing the court's attention to what is, in my submission, quite a helpful summary of the particular prominence and protection afforded to free expression in relation to a matter of public interests, and in particular that includes issues related to the functioning of the system for deciding custody rights and the fate of children. So I think that, in a sense, supports the submission that I had made earlier, that insofar as the open justice principles might apply to the framework of family proceedings in the context of the statutory exemptions, in a sense, the existence of those protections emphasise the importance of free expression and, of course, the role of the media as the watchdog in proceedings that the public cannot themselves access. So I hope that assists, and I apologise for not having addressed the hard copy to my lady.
Please don't.
In relation to the framework of the application itself, I wanted to draw attention to the decision of the Court of Appeal in Re C. That was an appeal from a decision of Mr. Justice Porfley, and that's at page 201 in the authorities bundle. That relates to the publication of the judgment, in fact, I think my lady's judgment, in respect of Ellie Butler. And an application to publish that judgment after the conviction of the parents in relation to
201 of what? Of the authorities bundle?
201 of the authorities bundle.
The Bassi?
Nope.
No? Okay.
I think Abassi is somewhat further on. Apologies. I think Abassi may be 301, but...
Okay. All right, got it.
Does my lord have that? Thank you. It was only that in the course of that, and obviously the now President, then Lord Justice McFarlane, sat in the constitution of that court concerning the publication of the judgment, there was consideration there, and it's at paragraph 9, the power to make the order for the publication of the judgment sought by the media organisations. There was a submission made there that there was jurisdiction under Rule 12.731B of the FPR, and again, we can provide that if that assists. But ultimately, the court preferred the alternative submission, which is recorded at paragraph 11. And at paragraph 12, stated the view that the court has the power under its inherent jurisdiction to relax the automatic restraints that might apply. I think it's right to say that obviously that decision is now 9 years ago, and whether there has been a greater focus on the court's case management powers, particularly when the establishment of the transparency regime has been about the more prosaic and consistent relaxation of restraints through the transparency order process. I don't think it would be suggested that in each case that a transparency order is being made, that is invoking the inherent jurisdiction. And so...
So what is it invoking?
Well, respectfully, it may well be that it... so Rule 12.73 notes that for the purposes of the law relating to contempt of court, information relating to proceedings held in private, whether or not contained in a document filed with the court, may be communicated. It then sets out a list of individuals who can automatically be communicated.
What are you reading from?
Apologies, this is the practice, this is Family Procedure Rule 12.73. I can have that emailed across if it assists.
12.73 of what?
Of the Family Procedure Rules. The catch-all within that framework of rules, there are obviously a number of individuals who can automatically be provided with or have information communicated. The catch-all at 12.731b is where the court gives permission. Now that was engaged with by the Court of Appeal in Re C.
Sorry, you're just going to have to take this a bit more slowly. 12.73.
Paragraph 1b.
It's the Family Procedure Rules 12.10. 1C.
12.73. So it's 1273.
1C.
1b.
B. For the purposes of the law relating to contempt of court.
Yes. So the nature of that rule is obviously engaging with the structure under Section 12 of the Administration of Justice Act, because that is where a potential for contempt arises for the communication of information relating to the proceedings. The rules here and the architecture of Section 12 permits deviations from what would otherwise be contemptuous communications where the rules or an order permits it. Under 12.73, the communication of information is permitted when you come within subsection or rule paragraph 1 or 3, and so that allows under 12.731a communication to parties, legal representatives, and so on. The Court of Appeal in Re C appears to have accepted a submission advanced, I think, on behalf of the number of by Mr. Dean, that nothing in this chapter permits the communication to the public at large or any section of the public or of any information relating to the proceedings. But I suppose it rests on whether the scope of permission to communicate under 12.731b might be said to extend more generally, whether that is inhibited or not. I don't know whether paragraph 2 might be read in as much as the chapter doesn't permit communication to the public at large. But the tension between a general permission, which might be said to be given under paragraph 1b.
I mean, the answer is in VC. The Court of Appeal says it's in jurisdiction.
And that is the basis on which our application was made through a C66, which is an application within inherent jurisdiction proceedings.
Yes, but the question is not whether there is power to relax the reporting restrictions. The reporting restrictions imposed by Section 12 or even imposed by the court. The question is whether there is power to anonymise the judges.
Yes, no,
That power comes from.
I accept that. I suppose I was seeking to address the broader context of the relaxation and so on. Whether that engages with the architecture of the transparency order, which I don't know whether it explicitly in all cases is reliant on the inherent jurisdiction, and but that may obviously be an issue for another day. But I flagged Re-C because that interplay as between the rules and an application under of the inherent jurisdiction arose there. I don't know whether the court might incline to a more or less expansive view, but that seemed to be the territory. And if Re-C is to be followed, then the suggestion is that the inherent jurisdiction is the basis, as they understood.
Okay.
Obviously, that's addressing in part my lady's broader question about what flows from the type of application that my clients made, and the application for reporting restriction orders and the CAFCAS note. As I say, we would respectfully submit that where Section 12 of the Administration of Justice Act doesn't provide for any particular information to be restricted, and that includes the name of professionals, the name of experts, the names of judges, then in an application brought by a member of the press, a news reporting organisation, or I suppose indeed a participant in the proceedings for a relaxation of those restrictions, we say that broader obligations of notification don't arise under the reporting restriction order framework, insofar as there is often a response to a request to relax those statutory restraints, an application then for reporting restriction orders to be made to balance the point. And Mr. Justice Williams comes to the point where he says, again, in slightly surprising comments in a judgment without notice, that Section 12 should be amended because it can't be right that a child can be named after the end of proceedings. But it does often flow that if there is a request to report or publish information relating to the proceedings, that one party or another might say that in the circumstances the appropriate balance is to impose a reporting restriction order to protect the child because Section 12 doesn't provide that anonymity once proceedings have concluded under Section 97. That goes to my broader response to the suggestion, or whether implicit or explicit, that there was some defect, deficiency, or lack of anticipation on the part of certainly my clients or the broader media of the fact that there would be publication of names. We say, of course, everyone should have been aware of that. Mr. Justice Mumby, as was in Ward, set out in very clear terms the delineation of what is and isn't protected under Section 12 of the Administration of Justice Act. We are applying to remove to vary the statutory restraints that engages the rights of the family members, It is obviously something that is known to those who represent the children. It is known to the local authority where they've been involved in public law proceedings, and so they will have notice as a consequence. But there is a tendency to seek to expand the degree to which there should be notice of issues to others who may be functionally not reported upon whilst there are restraints that go to protecting the child, but once those restraints are removed, there's no proper basis for them to be protected, and that it is addressed to some degree within the Reed W decision in the Court of Appeal, where Lord Justice McFarlane, I think, giving the lead judgment, emphasised that where an expert has come to court and been cross-examined, they have been challenged, there's no particularly obvious reason why they should have notice of a judge coming to conclusions on that evidence that may be critical, but distinguishing in that case between those who have had no notice of a potential finding, no opportunity to respond, where a different procedure might be said to arise. And we rely on that in part about the unfair process the judge adopted as regards my own clients and the media more broadly. But an ever-expanding pool of people who may be, as it happens, made more difficult to report upon by virtue of the primary statutory restraints, that is a sidewind. It's not a principled restriction, and it isn't one, in my submission, that is where the balance has been drawn by Parliament, and so it shouldn't be protection that is expanded in line with the conventional approach that incursions on the open justice principle should be exercised in a restrained fashion, consistent with principles and in particular with the statutory framework.
Can I go back to the President's guidance, which I referred to this morning, his guidance as to reporting in the family courts that I've mentioned this morning, dated the 3rd of October 2019. In that guidance, he specifically talks about guidance on the approach for applications by journalists to vary or lift automatic reporting restrictions. And I thought initially when I read your submissions that your feeling of injustice about the criticisms about the manner in which the application had been made came from this, because although it, as you know, says that the application's made under Form C66, it talks about that being time-consuming, expensive, and generating additional unnecessary public expense, and says that it can be dealt with by way of an email, which Ms. Tickle may say that's precisely what I did. But what I needed your help with about this is all this guidance seems to work on the basis that it is a straightforward 8 and 10 analysis.
Yes, insofar as it encapsulates the status of the current law.
Yeah, I absolutely. But I'm. So I'm just is your position that you say that this guidance, obviously it's guidance, it's not a statute, it's not a rule. Are you saying it's wrong, or are you saying it's limited only to specifically to the protection of children, and therefore convention rights don't kick in, as is suggested in here, immediately upon the application, and that's the basis that the decision should be made?
Well,
for my part, I do need, seeing that guidance seems to suggest that whatever other errors the judge may have fallen into, and you've highlighted those very helpfully, that to say that he made a decision as to whether or not reporting restrictions should be amended to exclude social workers, etc., and judges, is governed by 8 and 10? Or do you say judges were never a consideration, no one ever thought it anonymised, and so this is very limited and should be
Yes.
regarded as such?
I think the reality that I confront is that the court has, in the course of Abassi, considered the position of clinicians
Yep.
and has considered the Article 8.10 balancing exercise to be the appropriate framework. There are various then points that are made as to how likely or otherwise it is that Article 8 might surmount Article 10 rights. But insofar as this note can't make law, insofar as it's summarising the existing jurisprudence, that has to be bound by the existing jurisprudence, which doesn't touch the issue of judges in this context. There is a lively jurisdiction as to, in the circumstances in which professionals, social workers, guardians, experts might come to acquire specific protection that isn't, in our submission, afforded to them by the rules. But to expand it, certainly to expand it beyond its own terms, beyond the basis of the case law that it seeks to summarise to include judges, in our submission would be unprincipled.
Thank you.
Yes, I think it's only to emphasise that insofar as the architecture of the transparency pilot and programme, that does, again, in the course of orders, express certain default starting positions in respect of a whole range of people. Again, it's beyond the confines of this appeal, but whether that addresses the right balance it may be an issue for another day, insofar as that pilot sets that default. But again, the transparency pilot doesn't contemplate the anonymisation of judges at any stage within it. And obviously, the transparency pilot is built on an expanded rather than reduced knowledge of proceedings before the family court. And for the avoidance of doubt, those before me undoubtedly would submit a not before time, and efforts in that direction are obviously welcome. Whether the contours of the pilot prove successful or draw the right balance, no doubt will be tested over time.
About a pilot, isn't it?
Indeed. Well, it's sufficiently successful to now be intended to be incorporated in the rules, which, again, formalises the matter, albeit there is the tension if the formalisation of those within the rules sets a default position that accumulates additional anonymity within the system, then that may be something of a misstep, but it obviously has to be balanced with the broader rationale behind it of increasing the generalised publication within proceedings. But I don't think, insofar as my complaint arising from the order, from the application having been required, we accept firstly that this might imply that there is a greater level of informality when one is addressing having attended a hearing and seeking permission to report, as opposed to an application in very complex proceedings in relation to historical papers where a properly formulated application may be said to be preferable, and my clients undertook that. I think the contrast was between those fully participating in the proceedings who had not taken that step, and that caused little difficulty, apparently, to Mr. Justice Williams in making the order to protect a whole variety of other people who, up until that 9th of December decision, there was no restraint applying to them. There may have been a restraint in that until the point at which disclosure of documents arrived, we wouldn't have known who a particular person was. But again, that is not a principled restraint. That is a sidewind consequence of some of the other protections that apply. I think beyond that, encapsulating the appeal overall, I would only rest on the degree to which there is very strong support for the importance of knowing judges within a common law framework, given their constitutional position. The fact that something has never been done before might not necessarily imply that it could never be done, but it should certainly give pause as to whether you are in a manner consistent with the open justice principle, properly applying the limits that should properly be encountered, because fundamentally, as the note that we supplied to Mr. Justice Williams predicted, to a degree, particularly acting in a procedurally non-compliant fashion and in a way that doesn't necessarily afford proper protections to the principles that should be applied, has a particularly deleterious effect on confidence overall. And if anything, the transparency pilot and the recognition within the President's report is that there is proper public interest in avoiding that slope, so that there is better informed awareness of the functioning of the family court, and that the communication of that information in an overall manner is a positive. Now, insofar as we reach the point that a balancing exercise might be said to arise if you're against my case, I say that all falls in favour of not having restrained, but you're aware of my broader position on the jurisdiction. I think, having been diverted to outcome at a slightly earlier stage of my presentation, I don't intend to wheel around to it again at any length, save to say that we maintain the position that the order should be set aside. If the court wishes to set up an appropriately time-limited opportunity to be aware of what the outcome will be in order to take steps, and obviously that is unusual and probably requires permission given the ordinary fact that the communication of an outcome can't necessarily go beyond. There may need to be specific provision to account for that. In a sense, it may be that both the judges affected and the media parties who may have to respond can take appropriate planning steps for that judgment hand down if there is a time frame that is known. And I think the court has my point on our broader concern about, insofar as the media applications continue to be live and due for review, that the various serious concerns about the approach, the wrong approach that the judge took, the unfair approach that he took, the unprincipled approach he took to the media parties generally, but the appellants specifically, give rise to a need to properly allocate those important applications and to a different judge of the division. Beyond that, conscious I've now been speaking for a considerable bit of time, unless there's any other matter that I can assist at this time, those were the submissions that I had.
Thank you very much, Mr.
I'm exceptionally
Barnes.
grateful. Oh, apologies. One other matter that I should add is that I have been in communication with Miss Reeves, who was junior counsel, who assisted with the note on behalf of the judges. The indication she gave me was that insofar as the question of consideration of the publication of that note arises, she is, I believe, seeking instructions and is likely to be able to email the court with an update as to their position by the end of the day. I don't have any difficulty with that, but I indicated that I would pass that information on.
Okay,
I hope that
thank you
assists.
very much. And I think it's Mr. Wolanski next.
I adopt all of Mr. Barnes's submissions. I have a few points to develop. First of all, the question which is obviously at the heart of the court's consideration, which is the question of jurisdiction. Identifying that a judge has sat on a case does not engage Article 8. The mere fact that a judge has sat on a case does not engage that judge's Article 8 rights. The judge is in a public function. And it makes no difference if the
It
judge...
doesn't engage his or her Article 8 rights.
His or her Article 8
what you would
rights.
say, yes.
The judge is sitting on a public function. It makes no difference if the judge is sitting in the family court or in any other court. And as we say in the skeleton argument, even in courts dealing with the most sensitive matters, in particular of the Special Immigration Appeals Tribunal dealing with national security matters, judges are identified. Secondly, where there is sufficient evidence that Articles 2 or 3 are engaged, then the position is different, and the court can, and indeed on occasion must intervene to take steps to give effect to those rights. That is not the position in the current case. Thirdly, if that very high threshold is not reached, then it is, in my submission, very difficult to envisage circumstances in which the Article 8 rights of a judge to a private and family life are engaged by reason of identification of that judge as sitting on a case.
Well, hang on a sec, that's a bit circular. You've said they're not engaged.
They're not engaged by the mere fact of publishing the fact that they are sitting on a case. Now, what is suggested is that where publication of the fact a judge is sitting on a case risks leading to interference with that judge's private and family life, for example, by reason of a media firestorm, then that may engage Article 8. That's the suggestion that's made. That's the suggestion made by the judge in the judgment, and I believe by one or two of the parties to the appeal. Now, in our submission, it is very difficult to envisage a situation where that in fact arises.
In circumstances where Article 2 and 3 are not.
Exactly. Exactly. That is because judges are expected to be robust. And we see that from two cases which are in the bundle. The first of those is the Felixstowe Justices case. Can I ask you please to look at that? It's at tab 1. Starting at page 15. And this was a case in which justices had been subject to harassment. And that was the reason for the policy put in place by the Felixstowe Justices. At H on page 15 of the bundle, so it's page 594 of the report, what is said is this: many of the persons I have mentioned are subjected to criticism, vilification even at times, and suffer from being pestered by telephone and otherwise by persons who bear some grievance, and moreover, occasionally, by being wrongly approached by the press. But such intrusions into their private lives, judges and others have inevitably to put up with as a tiresome, if not worse, incident of holding a judicial office. Consider too the position of jurors, interference with whom is unhappily not unknown, especially these days. They are known persons, their names are announced in open court before they take the oath. I can easily understand that from time to time, those justices who are subjected to intolerable invasions of their privacy think that they ought to have some protection against this form of unjustifiable behaviour. However, while some forms of protection against intrusion into privacy are available and often used where necessary, I do not see how in principle there can be any justification for a policy the purpose of which is to keep secret the names of justices both when they are sitting and afterwards. So what is clear from that is that the Court of Appeal is saying that even intolerable invasions of privacy do not warrant a policy of anonymity. Lord Justice Watkins continues in that paragraph, collective responsibility is not, in my judgment, a good sufficient reason to defeat the principle, which I believe to be that where open justice prevails, so shall those who do justice be known. And I mention that because there is a suggestion by the judge in the current case that really, where criticisms should be made, if they can be made in the historic proceedings, they shouldn't be made at individuals, because there is a collective responsibility on the part of, as he put it, the system. That is a distinction the judge draws. We say it's a false distinction. Judges are the system.
I think he's making a different point. He's making the point that in this context, it's the practice not to make fact-finding decisions because of the limitations on the resources and the way that that would cause the system to collapse or be blocked. And therefore, there may be criticisms to be made of the allocation of resources drives that judicial policy. That doesn't justify any criticism of an individual judge in a particular case for failing to conduct a fact-finding hearing and doing what Judge 3 did in this case, which is follow the usual procedure. So that there is a real distinction there between the way the system operates and the way that the judge operates within the system, given the resources that are available.
That's certainly the judge's view, and one may agree or disagree with the view. I'll come on to it later. That we say is straying into the question of editorial judgment, editorial choice, discretion. The fact the judge takes that view is not a reason for anonymising the judges. But I take your lordship's point that that's the reason. There may well be something in what the judge says, but that's not, in our submission, a reason for anonymity. That's Felix Stowe Justices. The other case, your lordship's knowledge should have been taken to it already, but I'm going to say a little bit more about it, is the Harris case, which is at tab 2. Now, the facts of the Harris case are quite striking. Mr. Harris was a disaffected father in Children Act proceedings. He was found by the court to have acted oppressively, abusively, and unreasonably in the proceedings. Examples are given. He put a brick through the window of an expert. He repeatedly breached injunctions. He had threatened and sought to exert wholly improper pressure on the official solicitor and his staff, and on social workers. He had demonstrated outside the house of the president of the family division at the time. He had promoted tendentious accounts of the proceedings. He was described by Mr. Justice Mumby, as he then was, as devoid of moral scruple, and as an unprincipled charlatan. The question that Mr. Justice Mumby addressed in the case was whether the restrictions that had been placed on Mr. Harris publicising his case should be left in place. So those are restrictions that stopped him from protesting outside court buildings and at the houses of judges. The relevant section on publicity starts at paragraph 324. For present purposes, and you've already looked at paragraph 372, can we go, please, to paragraph 388?
388.
Yeah. Well, start at 368, page 64. This is the passage where Mr. Justice Mumby says the freedom to publish things which judges might think should not be published is all the more important where the subject of what is said is the judges themselves. Then your attention was drawn to 372. Then, please, 388, which is at page 70. What is said is this: the remedy for Mr. Harris's antics and the proper antidote to his public demonstrations, his protests, is not an unprincipled and probably futile gag him. The remedy is for publicity, for the truth, which at present lies concealed behind his unfounded complaints. Then there's a quotation from Judge Brandis. And then Mr. Justice Mumby says this: moreover, there is, I suspect, force in the view that enforced silence, which might erroneously be seen, if only by the malevolent, is intended to preserve the dignity of the bench, would probably engender resentment, suspicion, and contempt, much more than it would enhance respect. Then, further down, paragraph 390, Mr. Justice Mumby says this, which my submission correctly reflects the way the law should proceed in this field. In conclusion, I add only this. Her Majesty's judges will not be deterred from doing their duty by such antics as Mr. Harris and his associates are indulging. No amount of intimidation, whether demonstrating outside their courts or outside their homes, vilifying them on the internet, or bombarding them with offensive letters, will have any effect on the judges or their families, or deflect the judges from their sworn duty to do right to all manner of people without fear or favour, affection or ill will, or alter their approaches to the cases which they are called upon to try. I wish to endorse in the clearest possible terms, associate myself with what the official solicitor said in his letter to Mr. Harris. I deprecate your repeated threats to escalate public demonstrations specifically aimed at judges or others in your case, unless the court orders your contact to be increased. You fundamentally mistake the commitment they give to upholding the rule of law. This office will continue to do what it believes to be right in representing the best interests of the voters and will not be deflected by such threats. So that correctly in my submission reflects the fortitude that judges must be expected to display, even in the face of the antics of individuals such as Mr. Harris.
Just, can you remind me what happened about that aspect of his behaviour which involved loitering and outside the homes of individual judges?
No injunction was granted to prevent that on that occasion. I don't know whether there was any subsequent attempt to stop that.
I can see what he was saying about judges not being deflected. It's not so easy to go along with his proposition that none of this vilification will have any effect on the family. But that might be regarded by him as an acceptable price that the family have to pay for the judicial office. Is that how he viewed it?
Yep.
Anyway, he set aside those orders, did he? And
He set aside the orders. That, as I say, correctly reflects the fortitude that judges must be expected to display. And that, in my submission, is relevant when it comes to consider the question of the circumstance in which Article 8 can properly be said to be engaged through the naming of a judge. And the judge in the current case falls into error because he draws an equivalence between, on the one hand, judges, and on the other hand, other professionals who work in the court system. And it's a false equivalence because other professionals who work in the court system are not to be expected to put up with the kind of behaviour that individuals like Mr. Harris inflicted in that case. Judges are on a different position. So it is, in my submission, very hard to see what room there is for Article 8 to play a part where naming of a judge is under consideration.
Well, I mean, you can envisage Article 8 coming into play if there was a threat to picket the judge's home, attack the judge's children, or maybe not attack, but make life difficult for the children. I mean, I'm not trying to think exhaustively, but you could imagine that his or her private family life would be infringed and jeopardized, in which case Article 8 would come into the equation. But we're not in that case here.
We're not. I'm not saying it's impossible to envisage circumstances, but they will be very unusual.
And I think you would say that if such circumstances did arise, it's highly unlikely that anonymity would be the solution.
That too. Your Lordship's absolutely right.
Yeah.
And there may be other remedies. I mean, obviously, if the threats come from someone anonymous, it's very much more difficult. If they don't, there may be other remedies that the court could contemplate.
I mean,
Sorry. Oh, you go. Well, Mr. Barnes made the point that the judge's examples of actual instances are of judges who were known to the person carrying out the objectionable behaviour because they had been the judge in their case, and so anonymity would be futile.
It's a different situation.
well, the thing about anonymity being futile is that it's inevitably going to be futile because in this case, and probably in any other case, it's easy as pie to find out who was sitting in the Guildford County Court on the 14th of January, whatever date. You know, so this is always locking the stable door after the horse has bolted.
I agree.
Yeah.
So, having identified that it's in principle difficult to see where Article 8 really has a role to play. It's not impossible, but it's difficult in cases concerning the anonymity of judges. One looks at the judgment itself, and the judge himself fails to grapple with the question of how the things which he says may occur in fact engage Article 8. This is a notable shortcoming.
Where are you looking?
For example, paragraph 76. The judge talks about the likely level of online abuse, and there's a real possibility that some individuals may go further, much further. And then there's reference to a report in the BBC of a man who attacked a firm of solicitors in the Daily Mail, after a Daily Mail article. What the judge is not saying is, yes, well, translated into the current situation, the risk against the judges in the historic proceedings is as follows. Similarly, paragraph 78, he says at the bottom of the page, however, the greater the notoriety of the case and the greater the risk of infringement of the Article 8 rights, and the more serious the potential consequences, the more that will weigh in the balance against naming. But he doesn't say what the infringement comprises. He uses it as a, if you like, label or a catch-all term to describe any possible adverse consequence that may affect the judges in the historic proceedings. But that, with respect to the judge, is not good enough. Similarly, at paragraph 83, he says, the evidence set out above establishes a clear and imminent risk of serious infringement of the Article 8 rights of all the third parties, including the judiciary.
There's no evidence before him at all.
No.
I mean, this is not evidence. This is his own
Concerns.
knowledge or concern.
It is. And he continues in that paragraph, I do not accept the submission that evidence needs to be individual specific. But he's fallen into error because he has failed to approach his task in that way. It does need to be individual specific.
Well, I mean, it may not be, but it needs to be evidence.
And then over the page at 84, he says for the third parties, and that includes judges because he combines judges with others and he calls them third parties. The third parties, their Article 8 rights need to be of less weight to displace the Article 10 rights to name them, and I'm satisfied that the balance falls in favour of not naming them. Well, as a proposition of law, that's...
In his own cases.
It's mystifying. But what he's not done is said, well, in what respect are the Article 8 rights actually engaged on this evidence?
Yeah, okay.
He just doesn't do it.
Well, I mean, he couldn't actually know what our genuine Article 8 rights about the private and family life of the judges were.
No.
I mean, he couldn't know unless he knew who they were and knew them
No,
and had received evidence from them.
he didn't have the material.
Have them.
No. In my submission, it will be very difficult for the court in any case to establish jurisdiction under Article 8.
What do you do? You see, this is the thing that really bothers me. What do you do if you're a judge and you have genuine concerns about? I mean, there could be cases even higher profile than this. There could be cases where there have been real threats to the judges, and yet you need to make a quick decision. What does the judge do?
Well,
I mean, because setting up some incredibly elaborate structure to get evidence from the judges and submissions from 13 counsel, a raid in court for, is not for every case. It would just gum up the whole works, and it would itself inhibit the press fairly reporting material that ought to be in the public domain. So what, I mean, in today's world, it is clear that the internet has created greater, anyway, perceived risks to everybody, and that must include judges. So what does the judge do properly? Because that's what we need help with. Even if the judge was wrong, what should he have done?
Well, if there is a case in which there is proper evidence of a real immediate threat to a judge's safety, then there will be a basis on which an application could be made by someone acting on the judge's behalf for appropriate measures. Whether that will extend to anonymity will be a question for the court. Courts can act instantly if required to do. There will be circumstances in which a court will be called upon to act instantly. It's difficult to envisage exactly how that will play out, but courts are well equipped to deal with important applications on very short notice and make orders.
See, what I'm interested in is the threshold, really. Where do you get from a situation where the judge is fully entitled to say, nonsense, judges are tough, the whole raft of the principles upon which justice is based in this country is that judges will be identified, they sit in open court, everybody knows their name, they don't have to know their telephone number or anything else. All that is the principled approach. So where do you move from there to any kind of inquiry to see whether they should be not identified? And it's quite hard, because is it one email online from some obvious outlier saying these judges should be whatever, something terrible should be done to them? I mean, we see that online a lot now, if you bother to look. I mean, one answer is don't look, but that may not be a sufficient answer. So where is the threshold? Because for my part, I'm incredibly unwilling to lay down some complex procedure that has to be followed in every case. I think we'll be giving the courts work for decades if we do that. But equally, we have to have a principled threshold. And if the principled threshold, I mean, is not, say, a real media threat, a real threat, what is it?
Well, in my submission, that is the threshold, because that's the threshold that's needed to engage Articles 2 and 3.
Right, but what engages 8?
Well, this is my submission. It is actually very difficult to see where Article 8 could be engaged in these circumstances. I'm reluctant to deal in hypotheticals, but it is difficult.
Never say never, but...
Never say never, but it is difficult. Certainly it's a long way away from the current case. And that's for the reasons I've tried to explain, which is the fortitude of judges. Judges are different.
Would it, I mean, just assume there's a threat by some person on social media which is, you know, the sort of disgusted, if I can put it this way, disgusted of Tunbridge Wells type person just going way over the top and saying these judges should be X, Y, or Z'd. Is that really a breaching of the threshold? Because if it is, it happens, it may happen a lot. And people may show up who want to delay proceedings or take more time, may go trawling the internet or even put them on themselves and say, look, there's a threat to this judge. We've got to anonymise them. I mean, that's absurd, or
Well,
potentially absurd.
Yes, Mr. Barnes referred to what Mr. Justice Nicklin said in the parliamentary case.
Yes.
It's one thing for the court to be presented with evidence of fears of that kind, but it's another to assume that that will be translated into an actual threat.
Yes, but that's really putting quite a lot of responsibility on some poor judge who has to distinguish between, you know, a threat that looks a bit unlikely to be carried into effect and a threat that is. I mean, we can, you know, there are many examples where things that you didn't expect happen. So, I mean, this is what I find the most troublesome aspect of this case, is what is that jurisdictional threshold?
Yes.
If we were to say, well, it's never Article 8, or almost never Article 8, only Article 2, and it has to be a credible threat, is that not itself a bit of a hostage to fortune?
Well, that in my submission is where we are.
That's where we are.
That's where we are on the authorities, and that is because, as I say, because of the unique position of judges. But never say never.
Yeah, it would be nice to have a tidier threshold. Well, I mean, I'm going to invite everybody to think about it overnight, because I do think we can go down rabbit holes with the procedural guidance and rules that obviously have not been drafted with any of this in mind. And I also think that there is potentially merit, well, I think it's quite clearly merit, in the argument that this applies to everything, not just family proceedings, and that the Section 12 and Section 97 are the only really material distinction for family proceedings as opposed to others, so that what we say about this threshold will apply very broadly. And the last thing on earth one wants to do is drive a coach and horses through the transparency of legal proceedings. I mean, we're here to operate in public. It's what we do. We have to be scrutinised, but not be exposed to known, well, not threats, but not be exposed to violence. Certainly.
Certainly, I don't take issue with that.
No, I mean it's difficult. Difficult. Anyway, yeah.
Can I move on to a related point? It's already been made by Mr. Barnes, but just to develop it briefly a little more with reference to the judgment. This is the point about and this is assuming that jurisdiction is found. So obviously our primary submission is there is no jurisdiction in this case. There was none, but the judge's approach to the application of the open justice principle was wrong. You've been shown paragraph 61 of the judgment, which is the judge's conclusion, as he puts it, which is that his conclusion on the naming of third parties and judiciary is therefore that there is no presumption that they should be named in shielded justice cases. Now, Mr. Barnes has already addressed you on the incorrect notion that family courts operate as shielded justice, certainly insofar as the naming of judges. The judge, that error is reflected in a number of other passages in the judgment, which I'd briefly like to refer to. First of all, paragraph 54, where the judge, having set out what Mrs. Justice Leven said in Derbyshire and Marsden about naming magistrates, lay justices, and legal advisors. Having set that out, he says this at paragraph 54, with the greatest respect to Mrs. Justice Leven, I am not bound by her decision, and I do not agree with all of her reasoning. It runs contrary to the decision in Abbasi that it appears to suggest that as a class, some people like social workers or legal advisors or judges can automatically be named, which the President rejected at first instance and which the Court of Appeal would appear to endorse by their affirmation that the ultimate balancing exercise applies in all cases. Now, what the judge is saying there is that Mrs. Justice Leven was wrong to suggest that judges can automatically be named. But that's right.
That is right, but it is slightly difficult to understand that sentence because the word which doesn't naturally explain what it's referring to.
No, that is so. But at the heart of the sentence, there appears to be a proposition which is plainly
No, the
wrong.
first bit is you say is wrong, yeah.
Similarly, paragraph 55, first sentence, the authorities all demonstrate that the court retains a discretion to refuse permission to publish the names of social workers, experts, and judges. Now, again...
Say maybe.
That's, again, not an accurate reflection of the law. It's not a question of just discretion, it's a question of necessity. And also, it's completely to underplay all the weight of authority about the fundamental importance of open justice, which I won't repeat. We set it out in our skeleton, and so does Mr. Barnes. And then finally, paragraph 57 of the judgment. What is said is this: if one applies fundamental principles properly, what it all comes down to is the ultimate balancing exercise conducted on the basis of evidence and experience. To say that it is beyond doubt that magistrates can be named is to paint the issue in a bright line manner, which I do not think is appropriate. And then a few lines further down, much of the jurisprudence on open justice is drawn from cases heard in public and so is of less applicability to cases where Parliament has implemented a statutory regime which is an exception to the open justice principle. But again, that is wrong because the open justice principle applies equally to family proceedings when it comes to the question that the judge was deciding.
Well, yeah. I mean, it's very dangerous, it seems to me, to take this balancing exercise as a table in a storm, to translate my own Latin, because actually it was said to be the solution to a particular problem in a particular era. And, I mean, obviously, you will reach a stage where you have the engagement of Article 8 rights, the engagement of Article 10, where you need to balance the two. And nobody is suggesting that's not good law. But it's not the whole story here, I think, is what you would be saying.
That's exactly right. That's exactly right. And the wealth of jurisprudence on the operation of the open justice principle is not reflected in the way the judge approached this.
And you would say, I suppose, that the fact that the President's guidance or even the practice direction sort of imply that that's the correct approach. It doesn't cover everything,
Well,
life, the universe and everything in the case of special.
Can I just very briefly address that point? So the relevant paragraph in the President's guidance is paragraph 14. And what it says is this: seventh, having considered the relevant evidence and submission about the balancing exercise between privacy and transparency by balancing ECH articles 8 and 6 and 10, and by having regard to the best interest of any child as a primary consideration. Now, the key words there are having considered the relevant evidence. Because if having considered the relevant evidence, in fact, Article 8 is not engaged at all, then the balancing exercise doesn't get conducted.
Well, if you haven't got any evidence, that may be...
Which is the current case,
Yeah.
as it happens. But that seems to me to be the answer to my lady's question about the practice guidance. It's not in fact out of step with the law if one sees that it starts by necessitating an analysis of the relevant evidence. Just a few other points. A factor which the judge had no regard to, and I know this was all done in a great rush, so it's not something I criticise him for, but it is notably absent from the judgment, is that open justice, one of the key reasons for open justice is the need to maintain confidence in the administration of justice. So it's a point reflected in a number of the authorities. The authority of the courts depends on people believing that what they are doing transparently and in public. And that is particularly so, and has been for a long time in the family courts. Can I ask you please to look at the Kent County Council and B decision, which is at tab 3. It's an old decision, it's 20 years ago, and it's a decision concerning the question of what disclosures a disaffected litigant should be entitled to make from Children Act proceedings. And the backdrop to it was that there had been a number of well-publicised miscarriages of justice, Sally Clark, Angela Canning's, the Munchausen's by proxy issue, and this was another of these cases. So the question here was, should the mother be permitted to make disclosures? In fact, the mother already had made disclosures, so one of the questions was whether she was in contempt of court. For present purposes, the relevant passage starts at paragraph 97 on page 117. And Mr. Justice Mundy, as he then was, says this: thirdly, and of great importance, as it seems to me in the present context, is what I've referred to as the public interest in maintaining the confidence in the public at large in the courts. Article 6 is intended, amongst other things, to promote confidence in the judicial process. There's reference to what was said in the Strasbourg court in the Prager and Oberschlick case. Regard must be had to the special role of the judiciary in society, guarantor of justice, a fundamental value in a law-governed state. It must enjoy public confidence if it is to be successful in carrying out its role. Then, at the top of the next page, there's an extract from Axon and Germany. The public character of proceedings before the judicial bodies referred to in Article 6 protects litigants against the administration of justice in secret with no public scrutiny. It's one of the means whereby confidence in the court, superior and inferior, can be maintained. And then 98, the need to maintain public confidence in the family justice system is particularly important at present when, as I've said, recent high-profile cases within the criminal justice system have given rise to a very anxious debate, which is no longer confined to the possibility of further justice in the criminal justice system, but extends also to the possibility of similar miscarriages in the family justice system. So here's Mr. Justice Mumby 20 years ago identifying this problem and the need for transparency in order to address it. Now, that need has not gone away. And where we are today is, of course, we have the pilot scheme and other measures which have been put in place in order to address the issue. It's a crucial issue, and it's not one that the judge had any regard to. It doesn't feature in the judgment at all, but it's very important. Next topic, Mr. Barnes has already addressed you on, which is that the court must proceed on the basis that media will fairly and accurately report proceedings. I'm not going to repeat what he said. It is notable that the judge approached, what saw fit to criticise, in particular the dispatches programme, without giving, it's not broadcast by one of my clients, but without giving the makers of that programme any opportunity at all to respond to these severe criticisms.
But I think your point is a more fundamental one, isn't it? I think you say, but correct me if I'm wrong, that SARCA is authority for the principle that the court should not engage in an evidential assessment of the prospect of fair and accurate reporting, but should assume, not presume, or not make a factual assumption, we should presume as a matter of law that's the approach that will be taken.
That's right.
Yeah.
And that's settled law. We have Re-B, which was the 5-judge Court of Appeal, in which exactly the same point was made nearly 20 years ago. SARCA, a number of other cases. Re-C in the family sphere, which we've looked at. It's a very well-established principle.
How do you spell SARCA?
S-A-R-K-E-R.
Yeah.
I won't say any more about that. The point is clear in my submission that's been developed by Mr. Barnes at length. The next topic is one I alluded to earlier, but it's that the judge saw fit to step into the editor's shoes. Now, the judge does set out at paragraph 47 of the judgment the passage from Lord Roger in Guardian newspapers, where it's about halfway down towards the top of the page. He says, more succinctly, Lord Hoffman observed in Campbell, judges are not newspaper editors. See also Lord Hope in Re-BBC. This is not just a matter of deference to editorial independence. The judges are recognising that editors knew best how to present material in a way that will interest the readers of their particular publication, so help them absorb the information. A requirement to report it in some austere, abstract form devoid of human interest could well mean that the report would not be read and the information would not be passed on. It's a very well-known passage. The judge himself cites it, but he then fell into the trap of stepping into the editor's shoes. So we have, for example, at paragraph 89, he says, it's about halfway down, the disclosure and publication I am permitting will fulfill in very large measure the Article 10 rights of the press. So this is the judge saying, well, I think that an article that says what I have said and reports only the disclosures which I have permitted is good enough. That's the judge being an editor. Similarly, at paragraph 73, the judge says, in this case, there are possible positive disadvantages to scrutiny in naming, suggestion that individuals are responsible for extracting important points of their jobs in at least an acceptable way. This goes back to the point that my Lord Justice Warby was discussing. But again, in my submission, this is the judge saying, well, really, what the press should be doing is looking at systems, not looking at judges. But that's the judge acting as an editor. And also, to the same effect, paragraph 85, halfway down, the judge talks about delivering a potential scapegoat or a verbal scapegoat who is not likely to risk a profound infringement of their Article 8 and worst case scenario, Article 2 rights. So again, he's saying, well, that's something really that the press shouldn't do. I mean, he may be right, but it's not his province. Related to that is the point that the judge himself said that the judges in the historic proceedings had conducted themselves in, these are his words, in at least an acceptable way. That's at paragraph 73. And that somehow diluted the Article 10 right in reporting. And that's paragraph 69 of the judgment. But in my submission, that's the wrong approach. It doesn't matter what the judge thinks about the conduct of the judges in the historic proceedings. What matters is that that conduct is capable of scrutiny by the public. And it's not for the judge to decide that because he thinks they did nothing wrong, they shouldn't be identified. That's not the correct analysis, in my view, in my submission. The court has already been addressed in detail on the judge's approach to evidence and the distinction between generic evidence and specific evidence. I won't go into it. One point which is of some significance from the Abbasi case, and of course we're awaiting the Supreme Court's judgment in that case, but it's an important feature of that case. Can I ask you please to look at page 350? Page 350, it's paragraph 121. At D, experience has shown that end-of-life proceedings can generate a firestorm on social media, sometimes fanned and taken advantage of by organisations and individuals with strongly held beliefs about the morality of withdrawing treatment. The firestorm often overwhelms calm debate. RROs become essential to protect the integrity of the proceedings and those caught up directly and indirectly in them. And at 94, the judge says that the court says this.
Para 94.
At para 94, page 345. At D, in the light of what had happened in other cases, the RRO was appropriately made when the end-of-life proceedings were in progress. So a distinction is drawn in Abbasi between the position when the case was ongoing, and of course end-of-life proceedings are conducted in open court. That's a very important feature of them, unlike cases in Children Act applications. And what the Court of Appeal is saying there is, whilst the trial is ongoing, there may be a need for an RRO to protect the integrity of the proceedings. Because if there is a firestorm whilst the proceedings are going on, that may affect the proceedings themselves. Now, this, of course, was not said with reference to identifying a judge. That was not an issue in this case. It was about identifying professionals. But once the proceedings are over, it is no longer a question of protecting the integrity of the proceedings. It is a question of whether or not the Article 8 rights of those affected are engaged. So that's an important distinction that is drawn in that case. Now, obviously, in the current case, we're not talking about ongoing proceedings. The proceedings had finished. The historic proceedings. So there's no question of protecting the integrity of the proceedings. And anyway, they're not end-of-life proceedings, so such proceedings, even if they were carrying on, wouldn't be going on in open court. Not unless a judge permitted that, which is unusual. Penultimate topic, very briefly, holding the ring. Again, Mr. Barnes has made the point. The judge at paragraph 6, Roman 3, says this, and this is at the very end of Roman 3, just before Roman 4. Any delay in the determination of the issue will cause minimal prejudice in the context of a matter of weeks, and holding the ring requires non-publication rather than publication. So what the judge was saying was the interference with Article 10 rights was minimal because it's just a holding the ring order. So what's the problem with that? In fact, it's 3 months. It's not a matter of weeks. In fact, it's 3 months. Now, that is, in my submission, wrong. News is a perishable commodity. Any delay is a serious interference with Article 10 rights.
The case we used to cite is Cambridge Nutrition, which said,
That was it.
this is before the Human Rights Act, but said much the same, on the basis that in practice the order, or even if in form interim, was final in effect. What's your submission about the characterisation of this order, which lasts until 2040?
It's a final order.
Yeah.
In my submission, it has an end date many, many years hence. It's a final order with a provision for review, but it is in the terms of a final order.
So we're not concerned with Section 12 of the Human Rights Act, which would have required the judge to make an assessment of whether it was likely that at some future trial the Article 8 rights of the judges
The judge had to
prevail.
make actual findings for the purpose of a final order.
Yeah.
Can I just check, certainly on my copy, a large portion of little 3 is in italics.
Yes.
At first I thought, where's that a quote from? But I don't think it is a quote. It's
It's a
simply
quote
the
from
judge's
him.
narrative, isn't it?
Yes, I believe the way that this, I wasn't there, so I'll be corrected if I'm wrong, but I believe the way that this, this emerged is that these were the judge's initial responses
Through his clerk, I think.
through his
also,
clerk
And so that's
to the grounds of appeal that were initially advanced,
Yep.
and they were then incorporated into the judgment. So they are part of the judgment.
Non-italicised,
Yes. Yes, Mr. Barnes says the non-italicised parts are Mr. Barnes's grounds, and the italicised parts are the judge's
yep.
response, initial response to the grounds through his clerk. Final point is the proposal made somewhat tentatively by the judge in paragraph 92, but picked up and run with by Mr. Larizardi today, that in future it would be wise to notify those who the media wish to identify of the media's intention to do so. So this is paragraph 92, final sentence, and this is under the heading "The Future." In future cases of this nature, it would seem wise to identify these points in advance, so that's points of identification, and to give notice to parties the press wish to name so that they could be notified. And that's with reference to judges and others who have featured in the proceedings. And that's not developed by the judge. Mr. Larizardi does develop it by drawing an equivalence between the position when it comes to naming individuals caught up in family proceedings or naming judges, and the position which arises when applications for reporting restriction orders are made against the media to prevent reporting. Now, these are totally different situations because, of course, the latter situation is a situation which where Section 12 of the Human Rights Act comes into play, and where the media have to be put on notice of any application which potentially affects the right to freedom of expression. And that's the genesis of the Kafka's note of the practice direction in 2005 and so on, because at that time what was going on was applications were being made, often by local authorities, for orders against the media preventing the naming of children. And the media weren't getting to find out about them, or only getting to find out about them in a very unsatisfactory way. And so the president, it was, this was named Sloss at the time, put in place a procedure which required the media to be put on notice so that Section 12 of the Human Rights Act was complied with. That is totally different from what is being proposed here, because what is being proposed here is that the media should give notice to anyone who it lawfully wishes to name. So if it wants to name a clinician, if it wants to name a judge, it should tell them so that the court can then consider whether that should be permitted. That proposal amounts to a requirement that the court licenses publication in advance. Another word for that is censorship, and it is not the way the English law works. This was explained by Mr. Justice Mumby in the Warby case, which we've been looking at. That's the Munchausen's case. Page 130 of the bundle, please. Paragraph 145. Furthermore, the first part of the order sought seems to be that was an order requiring the BBC to notify again of a proposed broadcast. It is wrong in principle to require the media to give prior notice of some proposed publication broadcast. That is, on the face of it, a wholly unacceptable form of prior restraint. Worse than that, it is, on the face of it, a wholly unacceptable censorship. And then further down in the same paragraph, the truth is that what the local authority was seeking was the opportunity to approve in advance what the BBC broadcast, or failing agreement, the opportunity to apply to the court for an injunction. This, I am afraid, will not do. Licensing in advance what may be published or broadcast is simply censorship under a different name. It is not for the BBC to explain or seek permission to broadcast, as I had earlier had occasion to emphasise in Kelly, a case which, as it happens, also involved the BBC. Unless injuncted by the court, the BBC is entitled to broadcast. Those seeking to obtain an injunction to establish their case and to do so convincingly, if they cannot establish that case, then the BBC is entitled to broadcast. And that, in my submission, is a complete answer to the point. Unless I can assist the court any further,
No, thank you very much. Thank you very
those are my
much.
submissions.
Ms. Fotrell.
My Lords and my Lady, it may come as a relief to know I don't expect being more than about 20 minutes at +3. So what I'm hoping to do is to deal with four matters.
Is to what?
Deal with four matters.
Format.
First of all, very briefly, to remind the court of the local authority's position in relation to this appeal and how that has evolved. I'm going to make a very brief preliminary point about the proceedings, the wardship proceedings, and how these applications came to be adjudicated on by the judge on the 9th of December. Those are all matters I know the court is familiar with. I'm not going to go into in detail. If I may then just very briefly amplify some of what is said by us in our most recent document in relation to procedural errors that we say justify this court granting the appeal. And then lastly, to do what I can to address the matters raised, particularly by my Lord, the Master of the Rolls, in terms of the Article 8 points and the threshold point. And I understand that is where the court's focus now is. You will know that the local authority has lodged two documents in respect of this appeal. Just to remind you, the first is a note on behalf of Surrey County Council dated the 18th of December, and you will find that at 235 of the electronic bundle. That document, of course, was lodged with this court before the judgment of Mr. Justice Williams was available. And the local authority's position, as outlined in that document, was that it didn't advance a positive case. It identified a number of difficulties with the procedure. But of course, it noted that the judge intended to set out his reasons in a full judgment, which he did, of course, on the 19th of December. The second document from the local authority is the skeleton argument dated the 9th of January. That is at page 141 of the electronic bundle. And you will know that there's a modification in the local authority's position in that the local authority now presses on the court that the appeal should be allowed. Primarily, we say, because of the procedural errors made by the judge, and there is, if you like, some crossover between that and the substantive decision made by the judge, because it is very clear, having reviewed the judgment and having had an opportunity to consider the reasons contained in that judgment, that it simply wasn't possible for any of the advocates, but particularly the media parties, to address the matters that led the judge to make the decision that he did. And therefore, all of the issues which are being discussed before this court, including the very important question of whether there is any jurisdiction to make the orders that he did on the 9th of December, were not matters on which the parties made any submission. So the local authority does say procedure was fundamental in this particular case. The two preliminary points that I wanted to deal with very briefly, if I may, is just to remind the court of the position that Surrey Council takes in these proceedings generally, and it's obviously an important matter in a very sensitive and difficult case. You will appreciate that the local authority recognise and acknowledge that there is a legitimate public interest in the scrutiny of the actions of the local authority itself, discharging its statutory functions in relation to not just the subject children of the wardship, but most particularly in relation to the young child, Sara Sharif, of course, who died. And the local authority throughout these proceedings has been very clear about its recognition of the obligation and entitlement of the media to scrutinise actions taken or not taken by the local authority. And the local authority wishes to emphasise that point before this court today. That is reflected in my submission in two aspects of the conduct of these proceedings. At a very early stage in these proceedings, when the applications were made by the appellants on the 30th of September, or forgive me, the 30th of October, for disclosure of documents, the local authority was very proactive in its collation and organisation of those documents. And indeed, junior counsel Ms. Kayoun, who sits behind me, and Ms. Moore, the local authority solicitor who sits behind her, have laboriously undertaken that task so that by the end of November, the beginning of December, documents were organised into annexes and different bundles with a summary of the evidence, and all of that material being made available at various stages throughout the process. I only make that point because I know it's not a matter that is particularly before this court, but it does reflect the fact that the local authority acknowledged the entitlement of the press, and indeed, more importantly, the public to understand what it has done or what it has not done in the historic proceedings. The second point I just wanted to emphasise, if I may, and again, it's a preliminary point and only I just want to signpost it, and we make this in our document. The wardship proceedings in this case are immensely complex. They have involved hot pursuit applications made by the local authority in August 2023, seeking the return of 5 siblings of Sara Sharif. Those proceedings necessitated a range of urgent applications made out of hours by the local authority, and they were assigned to or allocated to Mr. Justice Williams in September of 2023. It is only right and fair to acknowledge that at each stage when Mr. Justice Williams has heard applications in this case, he has had the most challenging juggling act to undertake. On the one hand, dealing with issues related to the wardship, and on the other hand, very often in the same hearings, dealing with sensitive and difficult issues relating to publication and disclosure of material. And in my submission, that is reflected by the fact that there are 2 substantive judgments, one given in March of 2024, in which he continued the wardship, which reflects the knowledge and the care that he took in addressing the issues in relation to the wardship applications generally, And then, of course, there is the first judgment in relation to disclosure and publication, handed down by Mr. Justice Williams in June of 2024, in which he dealt with the issue of disclosure at that point and the question of publication going forward. And I only mention those points because one, obviously, and the local authority does, have particular sympathy for the judge with the matters that confronted him on the 9th of December, a hearing which was adjourned from the 3rd and 4th of December, and the range of issues with which he was required to grapple at that hearing. And it was, in fairness, we acknowledge, a very challenging and difficult hearing.
Yes, but that may be, but his judgment was 66 pages, all about this single issue.
I'm not going beyond the points that I have made, simply to the local authority acknowledges that the way in which these matters arose.
I mean, none of the other matters you've mentioned are criticised at all.
No, I acknowledge that, and I'm saying them out loud. They may or may not assist the court in they don't. Just then moving on to deal with the issue of procedure. The reason why the local authority, as we say in our document, I don't intend to amplify this, but the reason why the local authority has reached the position which it has in this appeal is that, as the court is aware, no party either asked the judge or even contemplated that the judge was considering making an order which would prohibit the disclosure and publication of the names of the judges. And one of the reasons why the local authorities say that is an important point to emphasise is that when my Lord, the Master of the Rolls, asks the question, how do we, in any judgment given by this court, set the parameters in terms of threshold and provide guidance to judges going forward, there is an important point to acknowledge, which is that this is not an issue which arises within either family proceedings or other proceedings. It is not an issue which arises that anyone is contemplating not naming a judge. And that is why it was a surprise, and this runs a thread which runs through all of the documents before this. It was a surprise to the media parties, and it was a surprise to the parties in the wardship proceedings, that the judge had taken the view that third parties included judges. And so, insofar as there may be some concern on the part of this court that setting out guidance and a framework going forward is either necessary or setting out a framework going forward may lead to floodgates and a range of applications, one starts from the point of view that there is no reported authority in which a court has prohibited the naming of a judge in circumstances in any way comparable to this, or indeed in other circumstances. And it is not a matter which arises. One has to start from the presumption that the judge will be named. And that is the fundamental procedural error, again, which the judge fell into, that if he was intending to take this unusual step, then it was incumbent on him to make that clear to the parties so that he could be addressed. And all of the difficulties which arise in relation to his substantive judgment and his decision, and the reasoning behind that decision, could have been explored and addressed if they had been aired, as it were, by the judge. It simply was not something which anybody could have anticipated or...
But do you say that he should or should not, in the light of his subsequent judgment and the concerns that are there expressed, have raised the issue with the parties instead of just announcing his decision?
If he was contemplating making an order, as he was...
I was hoping for an answer which didn't begin with if. If, on the premise that he had the concerns in his judgment, what do you say he should have done? Should he have asked for submissions before announcing or giving a reasoned decision? I think we can all accept a reasoned decision was necessary. Or should he simply have decided that he had no jurisdiction to anonymise the judges and dismiss the idea in his head?
Both of those points would have been addressed had he notified the parties that it was within his contemplation. Because one of the issues...
Well, the problem with that is that it creates hairs running at a phenomenal pace, as we see. And actually, possibly creates the media firestorm that he wished to avoid by even raising the question. Had he not raised it, probably nobody would ever think again about the names of these judges.
Well, perhaps there's a question before that question, which is, what was it that led the judge to have the concerns that he had? And is there anything in the judgment that sheds any light on that? And that might be related to the question that my lord, the Master of the Rules, has asked of Mr. Wolanski and Mr. Barnes, which is this a threshold issue? Is this an Article 8 issue? How is the box opened? How do you get through the jurisdictional gateway? And it may be helpful if I address that issue and make submissions in relation to that issue. The position that we take in relation to that, and you'll see we've flagged this up in our document, is that this court cannot say that there could never be circumstances in which Article 8 is engaged. Now, I've heard the discussions between my lord and the other advocates, and the position in particular taken by Mr. Wolanski. And I would make the following points.
Well, he says that.
Forgive me.
He says exactly what you've said.
Well, I haven't made my point yet. If I the point that I would make in relation to Article 8 is this. The scope of Article 8 is relevant because, of course, the scope of Article 8 is broad, and Article 8 includes a positive obligation on the court to consider, or a public authority to consider, whether or not it is engaged and whether or not Article 8 rights are at risk. There is, within Article 8, protection for psychological and physical integrity, which is related to Article 3, but may have a lower threshold for engagement than Article 3. That is something which emerges through the jurisprudence of the European Court of Human Rights. So we know that Article 3 is only engaged if the treatment or punishment complained of is sufficiently severe to engage Article 3. If it is not, Article 8 may still be engaged in relation to psychological and physical integrity. I'm thinking of cases dealing with issues like corporal punishment or strip searching or those matters, which fall within Article 8 but have not engaged Article 3 and do engage the positive obligation of the state, even if those are matters where the breaches are being carried out by private actors. And I can't, having made that submission, envisage circumstances where that would easily involve the rights of a judge, because psychological and physical integrity, and the two examples I've given are those that I'm familiar with from the European Court of Human Rights jurisprudence. But those are matters which are not easily going to arise in cases involving protections of a judge in the way that has been set out, for example, by Mr. Justice Williams. So the social media pylon, which my lord referred to earlier, would not, in my submission, meet that threshold for psychological or physical integrity. And I'm not going to speculate as to what might, but what I do say is that this court would have to be careful about saying that Article 8 would not be engaged in any circumstances because of the scope of it and because of the positive obligation. And both of those matters we can draw from the case law of the European Court of Human Rights itself. And that should, in my submission, assist the court on the question of threshold, because the threshold is going to be high for psychological or physical integrity.
Where do the words psychological or physical integrity come from?
It comes from the jurisprudence of the court. We'd have to track it back if the court wants us to make good. From my recollection, it arose in this jurisdiction in a case called Costello-Roberts versus the UK, which is a case from...
Could you don't do it off the cuff. If you could overnight give us the
yes.
authorities.
I'm happy to trace it back. It's something I'm saying in response to...
I only need one authoritative reference, but I need to see that it is a thing. I mean, when I said to you, you agree with him, he said exactly the same, that you can't say that Article 8 would never be engaged. But you've said something extra, which is that the threshold is very high and is related to psychological and physical integrity, i.e. the connection with Article 2.3, which is something different.
The point that I would make particularly in relation to this is that Article 2 and 3, and it's really in relation to Article 3, Article 3 has a high threshold to get over in terms of the obligation of the state because it's an absolute right. And once you get over the threshold in terms of the treatment and punishment, then the obligation bites. Whereas, of course, in relation to Article 8, one, even if you demonstrate psychological and physical integrity is breached, you then get into the balancing exercise in relation to Article 8.2, and then you get into the balancing exercise in relation to Article 10. And that's why, in my submission, and if this aligns itself with Mr. Wolanski's submission in a slightly different way, that's why in my submission the court has to be careful about saying never, but the court need not be concerned as to floodgates in terms of litigation or complications for judges at first instance, because that bar is high. Physical and psychological integrity of judges arising from publication of their name, the bar is going to have to be very high, either a vulnerability of the judge themselves or a specific identifiable threat. That has to be right.
Coming back to my question, the answer is that he should have said, don't be silly, that's not a point, and forgotten about it, and not said anything to the parties because the threshold was nowhere near engaged even on his own internal evidence. Is that right?
Had he had the opportunity perhaps to think matters through,
no, I'm talking about an ideal world in
Yes.
which, obviously, I'm not criticising him for taking a snap decision which turns out to be wrong. That's terribly unfair, and we never do that with judges. I'm just saying that in the ideal world, where the judge has this idea pop into his head, and he has endless time to think about it, in this case, what ought he to have done? And I think your submission is, having, this is always assuming that he had in his head everything that 3 days or 5 days later comes out in his judgment, he should have said, yes, that's all very interesting, but that almost certainly or certainly does not reach the threshold for Article 8. Article 2 and 3 are not engaged. The threshold there is terribly high. This is all sort of speculation and reading across from other things in the world. So I don't set the hair running. I mean, that seems to be the conclusion from the very helpful submissions you've just made.
well, that would have to be right, because if one goes back to where my Lord started with this question this morning to Mr. Barnes, I think the way my Lord put it to Mr. Barnes this morning was at 4 o'clock on the 9th of December, clothed with the knowledge that he was clothed with at the time, was there a jurisdiction to make the order? And on the evidence as it is subsequently set out in his judgment, the answer to that has to be no.
Yes, well, that's incredibly helpful, Ms. Farshall.
Does any of the Strasbourg jurisprudence tell us what they really mean by these rather lofty-sounding words, physical and psychological integrity? Because we tend to use the word integrity in a different way from the European Court. It means wholeness, I think, in their context. In other words, leading to some sort of physical or mental breakdown. That may be putting it too far, but anyway, does the case law actually put some flesh on the bones of that phraseology?
It may be helpful if we set that out in a little bit more detail, but from my recollection and understanding, for example, in the Costello-Roberts case, the issue of psychological integrity went to the intrusion on the dignity of a very young child who was, as I recall, snippered, I think, was the complaint. And so the Article 3 claim failed because the treatment complained of was not sufficiently severe, but it was not dissimilar to earlier case law around corporate functions. It was the experience of the young person themselves, that their own integrity, their humiliation, and those matters. But it may be, rather than my retreating back into matters that I was more familiar with some time ago.
I ask because my own recollection is that I haven't seen flesh put on the bones of that phraseology. They tend to talk in these rather general terms and apply them to the facts of a particular case,
They're very fact
which is an understandable way.
Yeah, they're very fact
operating.
specific, of course, as my lord has said. But what one is looking at is objective elements failing to meet the threshold under Article 3 and subjective elements meeting the threshold under Article 8. And that's the example with Costello-Roberts, that it's the subjective experience of the child. And so, for example, that also makes good our submissions and the evidence, our submissions that the court is hearing from other parties in terms of the psychological and physical integrity of a judge. And while one is not saying one is not sympathetic to the experience of a judge who is trolled or stalked or whatever the matters might be that are raised by Mr. Justice Williams, will they in any circumstances cross over that psychological integrity threshold? And that is a subjective exercise, but there would have to be evidence and there has to be a truth. So it may help if we clarify that my recollection is correct. But I think to answer my Lord Justice Warby's question, in Costello-Roberts it's a paragraph or two. It's no more expansive than that. But what is clear is that there is a line of jurisprudence in which the Strasbourg court has repeatedly said you fall short on Article 3, but you do engage Article 8. And
Well,
it's
this
a
is
positive
venables
obligation.
in domestically.
Yes.
That's venerable.
Yeah.
Indeed.
Yeah,
Indeed.
and the very, very small line of authorities that follows it.
Indeed, but also, my Lord, what may be helpful and align itself with the issue of Section 6 of the Human Rights Act is that it's the positive obligation under Article 8, the requirement to take proactive steps as opposed to remedy an interference which has already occurred. So, my Lords, the issue then, or where we say the court would arrive on that analysis, is that obviously it is difficult to say what cases will meet that threshold. It is difficult to say what the circumstances might be when a judge might have to ask the question, do I need to consider whether there are any particular circumstances around this particular judge? And one has to work on the assumption or the presumption that the answer to that will be no.
Well, we don't need to say, and we're not going to say, because we don't set out a blueprint of the law for every future case. All we need to say is whether the threshold was reached here. That'll be our decision. And plainly, the judge did have concerns, and whether anybody else agrees with them, they were real concerns that he then set out in 66 pages. So if that's not the threshold, then the threshold would have to be higher than that.
No, well, quite. And one is not ignoring the fact that the note which has come on behalf of the judges themselves identifies concerns. But that's not the issue with which the court is concerned itself.
No.
Those are the matters that I wanted to address you on. Is there anything else that you wanted me to do?
Well, we would very much like you to address the question of psychological and physical integrity.
Well, we'll find out if my memory is correct.
Well, that's good. And if you can help us to get straight to the point by identifying the passages you have in mind.
May I just mention one issue? I don't know whether it would assist the court at all to have a very short procedural chronology as to when the media applications were dealt with and what the orders that were made. I know that
It would
there
very
have been a number of
much
requests.
assist us. We already have one because my lady has been burning midnight oil. So
I used to be an excellent junior.
But we would much appreciate yours if that would help, because you have so much more familiarity with the case.
Well, I've said that without turning my back to us, Ms.
No, I can see I can see what's going on.
We'll do our best to produce that.
But we would appreciate
What
your
would be
changes.
helpful, Ms. Cottrell, is we, at my request, we were sent the wardship orders.
Yes.
Some of the orders are in the bundle, and this is no criticism of the incredible hard work that went into putting together the bundle. But some are in the bundle, some are in the wardship information. We need to meld them together,
Yes.
which I've tried to do, but I'm not going to.
Yes, very well. Thank you.
It would be great to get a little bundle of orders.
Yes. Thank you very much.
Thank you. Good. Well, I think we're on to Mr. Larizade.
My lord, my lady, I wanted to start by going to the appellant's skeleton argument at, and it's electronic 43. It's the last page of Mr. Barnes's document, in which he sets out the position in relation to the disposal of the appeal, to address 2 points. And the first point is really to deal with my lady's exchange with Mr. Barnes about whether or not he was advertising a future application. And he answered my lady, and I'd like to go to it. You asked him whether or not he was going to make a future application in relation to the social workers and the other professionals' names being disclosed. He deals with that actually in the document. What he says at paragraph 62 is, given the flawed, irregular and unfair approach adopted by the judge, the review proposed by the judge in relation to 1, professional stroke expert anonymity, and 2, reporting in respect of the ongoing wardship proceedings, should be remitted for case management before a different judge of the family division, with a review to take place promptly. I think there was envisaged at least a future application, and he was in fact inviting the court to allow it to be remitted to a different tribunal.
Well, he said that. He said if we remit it, we should remit it to a judge,
Exactly.
with a different judge. Yeah.
So he was certainly envisaging an application. In terms of paragraph 61, and one of the reasons which triggered our unusual application to attach the 2 annexes to our skeleton argument with some information for the Court of Appeal. It's the last sentence. In the event that such an application is formally pursued by any party to the appeal, this honourable court is capable of remaking the decision. So what I think he was envisaging was that if the Court of Appeal did not accede to the argument that there was no proper basis for anonymising the judge, and that issue should not be remitted, that in fact the Court of Appeal can and should make the qualitative risk assessment or the balancing exercise, essentially.
But they're different, aren't they?
They are.
Yeah.
They are, indeed. And so that led myself and Miss Wiggader to at least produce for the court 2 categories of information. I accept what Mr. Wolanski says. It's not in proper evidential format in the sense that it doesn't have a statement to which they are attached, and it doesn't set out the process which was undertaken in order to achieve the extraction of the material.
Would you still want to put that in?
Well, my lord, the bottom line is that having listened to the evidence, and I mean by that the exchanges based on the information that we've got, and the exchanges between the Court of Appeal and the advocates that preceded me, it is highly unlikely that this court is going to carry out any form of qualitative assessment on what is at best incomplete information, and it's not evidence. So the bottom line is that I'm not asking you to factor that in terms of
I don't understand.
Right.
I mean,
so
well, first of all, we haven't listened to any evidence. We've listened only to submissions.
yes,
Secondly, whether it's likely or unlikely is not something for you to judge at this stage. We have just heard some argument.
Yes.
And tomorrow we will hear more. So a judgment as to what's likely or unlikely is not helpful. And thirdly, we need to know whether you wish us to take into account the evidence you've put in, and we've read De Bene Esse. It creates a difficulty, really, if you are putting in evidence and are happy to, I don't know what the expression is, but afraid to strike. I've forgotten, there's a lovely expression about...
Willing to wound.
Yes, willing to wound but afraid to strike, whatever it is. Because we know what you put in, and it seems to me rather unsatisfactory for you to put that in and then just leave it there hanging and say, well, you can't do anything with it because I've withdrawn my application to adduce it.
Well, my lord, the position is that in relation to the first part of the first annex, which is to do with the reporting by Ms. Tickle.
Well, that's fairly uncontroversial.
It was referred to by the judge. We felt it was important that we should have the action.
Okay, but what about the second part?
The second part is that those are simply the extracts that we've managed to obtain. They are, I put in the application form information stroke evidence, and I accept that it's not in evidential format.
No, but it could easily be put in evidential format.
Yes, and I think the point that I wish to make is that they would be relevant if one is looking at a balancing exercise by the Court of Appeal at this point. And I am submitting that that is not something that is going to take place. So I'm not going to pursue that. But what I do want to do is to look at Mr. Justice Williams' consideration of the information that he thought was in the public domain, and the risks that he concluded were risks that he would take into account in reaching his conclusions. So they were
So on behalf of the father, you're maintaining that the judge's order should be upheld?
Yes. The
For the reasons he gave, is that right?
for the various reasons that he gave, and we've set those out in our skeleton argument. But the social media extracts were just simply examples of some of the threats that the public had made to the...
But I mean, presumably they're examples that your solicitor obtained or somebody obtained.
Yes.
I mean, you're not saying they're made up, they're real.
No, they are obtained by my junior,
Right,
Ms.
okay.
Whittaker,
Well,
who sits behind me.
right, okay.
They don't purport to be an exhaustive list.
No, of course not.
And there are some serious threats in those posts.
But the other side say a lot of them are not serious threats, but whether they are or not, they're very serious matters,
Yes.
which, anybody looking at them would be concerned in some way. But anyway, you don't want to admit that as evidence because you don't think we're going to conduct a balancing exercise.
I don't think the Court of Appeal will conduct a balancing
Well, I mean,
exercise.
that's a view that you have no idea about, to be with great respect. I mean, if we came, I mean, we've been discussing ad nauseam today the question of jurisdiction and threshold, but if we came to the conclusion the threshold was passed, but we felt the balancing exercise had not been properly undertaken, we might well have to take a balancing
My Lord,
exercise.
our position is that the proper course, if you decide that the learned judge was wrong, is to remit it to a different tribunal to be able to determine. But on full evidence, so that you would have evidence from the judges 1, 2 and 3. You would have a police...
I mean, the judges 1, 2 and 3 have said they don't think it's appropriate for them to give evidence. And I mean, speaking entirely provisionally, it seems to me that's a very reasonable approach. Judges very rarely give evidence about things of that kind. Why would they? They just make the position worse.
My Lord, looking at the notes that the learned judges
Yes.
through Mr. Purchase, Casey and Miss Reeves, from paragraph 12 onwards,
Yeah.
what they say is that each of them has serious concerns about the risks which would arise if they were now identified, particularly in the prevailing circumstances, including the content and often inflammatory nature of public and media commentary arising from the intense scrutiny which has followed from Williams J's judgment. And then importantly, and this is a point that hasn't really been developed yet, it's important to underline that those concerns relate not only to their own personal well-being, but also to their family members and others close to them whose interests the court may consider should also be taken into account. And so I don't know, because we don't yet have any information about this, whether or not they may wish to file information from their family members about the impact that that's on them. And if one looks at the next key point, which is paragraph 15, all of the judges consider that a proper and thorough assessment of the risks should be undertaken before any decision is made. And if that decision is made to make their identity public, then further assessment should be made of what, if any, should be taken before that decision is implemented. So they are envisaging, certainly, for there to be a proper risk assessment carried out. At this point, it's unclear as to what the shape of that risk assessment might involve, but it may involve a police risk assessment at the very least, in terms of what is out there and the threats that are...
So then what? What do you suggest? A hearing then takes place to evaluate those risks?
Exactly. Exactly. How else will the risks be properly assessed? I think that this is the difficulty. I would much rather that the Court of Appeal carry out a qualitative assessment, that you would need to have the full picture.
Do you want to make any submissions on threshold?
The submissions on the threshold, I would certainly invite you to focus on the fact that the Article 8 in particular, that everyone has the rights to a private life, and that must include judges, and the fact that judges would be an exception to everyone would just simply not be appropriate, and it's not what was envisaged by the article. Judges are obviously professionals. They're appointed, and they are engaged in terms of their Article 8 rights in a range of ways. So the argument that publication of itself would not engage the Article 8 rights is acceptable, but it's the aftermath of the publication, it is the effect that the publication will have on whether a judge can leave the house, whether or not the judge can communicate with his or her family, the fears and the anxieties the judge may have to increase protection in their property, and the additional safety measures that they may have to take for an indefinite period of time. So all of those things have to be taken into consideration. And not just, as we submit, the publication of the name. In this case, my lord, if the court was to determine that the names should be published, the publication of the names may also be accompanied by publication of photographs of the judges. We know, and I'm not speaking specifically of this case, there are many photographs on social media and otherwise of judges. And I can envisage, without a shadow of a doubt, that there'll be names and photographs to accompany those names. And I think that that is the story that Mr. Justice Williams in part was envisaging. So, my lord, what we say is that to take it at its most basic level, what Williams J was doing was saying that I will essentially make a reporting restriction order until 2040, but I will review this matter in May. I will review the matter once the judges have been given notice. They've been able to make representations, and indeed, if evidence is filed, I will review the same in May, which we say is the proper route that he decided to take on balance. My lord, if one looks at the judgment of Mr. Justice Williams, and in particular if one goes to paragraph 90 onwards, the future, one sees at paragraph 89, which is on electronic 94, in relation to the judge, I therefore also concluded that naming the judge would amount to a disproportionate interference with our Article 8 rights, taking into account all the likely impacts and risks that I have referred to before, and given that the disclosure and publication I'm permitting will fulfil in very large measure the Article 10 rights of the press. Now, he indicated there that he had carried out essentially an assessment of the likely impact, but not the probable impact, because he didn't have all the evidence to be able to determine definitively what the risks were, but these were the likely risks. And in 91, he says that I would not name any of those involved without inquiries being made of them as to their health and their response to the possibility of being named. The consequences could be devastating for them emotionally already, quite separate to any consequence, emotional or physical, to the fact of having their name placed in the public domain and linked to being responsible in some way for Sara being in the care of her father and stepmother who murdered her. And I think that, my lord, is the crux of it, that he was not going to make that decision allowing publication without allowing them the chance to be able to set out, at least in some format, their fears, their anxieties, and your lordships, and I know he's quite right, that we know nothing about the judges and their families. But what we do know is that the judges have written about their anxieties and their worries about disclosure. And in my submission, he uses the phrase, Mr. Justice Williams uses the phrase, holding the ring. But once you allow the genie out of the bottle, which is the phrase that we use, it's too late. And publication of the names would allow the genie out of the bottle before there's been a proper assessment of risk. The court made a strong and valid point about the damage to Article 10 of delay, and that was accepted by a number of the advocates for the appellants. The difficulty is that you can't sacrifice justice at the altar of speed, and the balancing exercise in my submission needs to be done carefully and properly, and one can't take shortcuts. It would be ideal that a summary assessment can take place, but in my submission that is a very unattractive route to take. It needs to be done properly. So, my lord, those are the points that I wanted to really develop. The other matter is that in terms of process, I haven't addressed you about that. And just briefly, I wanted to indicate to you that Williams J. offered a 2-day hearing, and none of the parties opposed the listing of this matter for the 9th of December for half a day, because it was hoped that perhaps by then we had the decision, the verdict.
I thought Ms. Tickle was keen to retain
So,
the listing. You
Maisie,
don't need to take to me, but just tell me if I've got that wrong.
You're not completely wrong about that. The actual email, which I thought was, I think, just summarised it nicely, if I may just go to it. Yes, here it is.
It's the supplementary bundle at 107, if that assists, my lady.
Sorry, core.
The supplementary bundle, 107.
Yes. We are concerned whether half a day is sufficient, but as you will have seen from our position statement, do not agree that the absence of a verdict necessarily precludes the judge from considering reshoots. That's for the judge to consider. So we've got no objection to the court being informed of the views of some of the parties at the 3rd of December as too soon. However, we wanted explicitly noted in any communication by you to the court that, as set out in opposition statement, we're open to a listing on the 3rd if the judge feels that it's appropriate. My gloss on that was that wasn't an application to retain the 3rd of December. It was a lukewarm, really position at best.
Okay.
that
Well,
makes it-
I think we're going to have to rise now, Mr. Lazaridis. So you can finish tomorrow. Maybe you could give just a little thought overnight as to whether you wish to maintain the application for new evidence in the light of what the court said. And I'm guessing that we'll finish probably well before the short adjournment tomorrow.
Yes.
Would that be fair? Jolly good. Okay, we'll see you in the morning at 10:30.
Oh, right, okay.